Okay, let's kick off, and as we'll carry on whilst people join. Ladies and gentlemen, it is my pleasure to welcome you to today's webinar. My name is Sue Miller, and I'm a partner in the Commercial Litigation Group at Stevenson Harwood in London. I will be your moderator today. I'm joined by Nate Lankford, a member of Miller and Chevalier Chartered in Washington, D.C., who will give a US perspective. Bianca, Bilton, Signorini, Antacli, a partner in TozziniFreire's environmental law group, who will give a Brazilian perspective. Daniel Lucien Bühr, a partner in the Zurich office of LALIVE, who will give a Swiss perspective. And last but not least, Galina Usorova, a senior associate in this commercial litigation group here at Stevenson Harwood, who will give a US perspective. Sorry, a UK perspective. As we've only got an hour and we already have 4 jurisdictions, we're without an EU perspective today, but it's very important to acknowledge the EU's leading role in environmental regulation and accountability. We hope to address that role in a future webinar when we will focus in on developments in supply chain due diligence. The EU has a wide-ranging new directive, and the Court of Appeal in the UK has recently made an important decision, which has wide-ranging implications for UK companies undertaking supply chain due diligence. We intend to leave some time for questions at the end. You can ask them then or add them to the chat, and we may be able to deal with them as we develop the conversation. So one of the key drivers of change in sustainability generally is financial regulation. So if you're a bank or an asset manager and your regulator requires you to make certain disclosures, you're damn well going to make them. Similarly, if you're a business and your investor requires you to undertake supply chain due diligence or to adhere to a specific code, you would be foolish not to do so. Things go wrong when you don't do what you said you would do, or if you're loose in your language regarding your green credentials. It's no solution to make no green claims at all. We've all heard a number of regulators here in London say that they want to discourage greenwashing. That is saying nothing, but they want businesses to make accurate statements about their green credentials. With that background, I'm going to ask Galina to start us off by telling us where greenwashing risk sits amongst other risks facing corporates. Galina.
Thank you very much, and hello, everyone. Well, what an interesting week to talk about greenwashing. I'm sure Nate will tell us more about what to expect from the new American administration and whether things are as unsettling as they seem from our side of the pond. But from the UK perspective, we constantly see GC surveys saying that ESG risks, including greenwashing, sit at the top of their non-financial risks. And given the amount of legislation, regulation, enforcement focus, and public scrutiny, that's hardly surprising. And when it comes to public scrutiny, I just wanted to share some very interesting findings from a recent UK poll done by Thornton Partners, where 62% of those surveyed said that they would assume the guilt of a business that is only accused of environmental wrongdoing. And even more worryingly for businesses, 75% of those polled wouldn't trust sustainability claims or credentials of a company that has previously been implicated in greenwashing. Given the sheer volume of green claims that are being made by companies, and I'm sure we all see on a daily basis, the stakes, as we can see, are quite high. They're obviously much higher in consumer-facing businesses and industries like transport, retail, and energy that get a lot of media and NGO attention. But we see from cases that we will discuss today, they're really not limited just to this B2C sectors. So that's my bit from the UK perspective. And Nate, I think you are about to kick us off from most anticipated jurisdiction.
Well, thank you, Galina. Over the past few years, there was definitely some momentum building in terms of federal enforcement from a U.S. perspective against greenwashing. And some really noteworthy cases that were brought by the U.S. Securities and Exchange Commission. And this, in combination with state actions and civil litigation by private litigants, had definitely made greenwashing a higher priority for companies. And so you definitely saw companies building structures and governance to look more closely at their disclosures and their sustainability reports and other public statements and marketing to make sure that the claims were appropriately specific and supported. Now, we're clearly this week at a point of like an important transition. I hope it's not news to anybody here or tuning in that the new administration has expressed extreme opposition to ESG in the past, and we expect that to translate into this area becoming a significantly lower priority for the government, for the federal government enforcement perspective. And so really the question on everybody's mind is like, does this really change the risk calculus for companies? Does it mean that companies should view greenwashing as a lower risk than it previously did? And in my experience, I feel like the answer is no, that the risks are still there, but they're likely to come in different forms and from different actors. And I expect companies to continue to take this issue seriously and perhaps increasingly seriously in light of developments elsewhere. We certainly expect state actions and private litigation to continue and to perhaps fill a gap that's perceived at the federal level. And also multinationals, as is obvious, operate in multiple jurisdictions, many with EU exposure and in other countries like the UK. And they have to deal with some very interesting issues of complying with those regulatory regimes and say regulatory regimes that may not prioritize the same issues in the US or that may in certain instances conflict with those and cause some tension with those. So I think that that's going to be a real focus for I think the legal and compliance community in the coming years. So I think the bottom line is that, there's still going to be a lot of focus on getting sustainability disclosures right, particularly on social issues, because those continue to be a hot button issue that gets a lot of bipartisan support in the US when it comes to trade related issues of supply chains tied up with forced labor, for example. And we expect that to continue in that form. But I think there's some interesting cases that will highlight, I think, this transition moment that we're in that I hope to get into a little bit later. But I'd love to hear from people from other jurisdictions of what you're experiencing.
So Daniel, what's your perspective from the Swiss perspective, amongst Swiss corporates?
Yeah, thank you very much, Sue, and hello, dear colleagues. So in Switzerland, the picture is definitely a bit different than what we're hearing from the US perspective. In Switzerland, the large multinationals, they are well informed about the legal requirements, but also, let's say, the expectations of stakeholders, and not a lot will change in Switzerland with regard to sustainability due diligence and subsequently also the aspects of green claims and the risk of greenwashing. What I observe in Switzerland is that there is quite a difference in understanding and also let's say compliance with legislation between the large multinationals and the smaller listed multinationals, and even more with the medium and small companies. So that's an area where I think there's still a way to go for leadership in the companies to understand what it means actually to respect business rights in the supply chain, but also to make objective and documented claims when it comes to climate, for instance. So there's still a long way to go. Overall, I think in Switzerland, the environment is very ESG friendly. Just to give you an example, beginning of this year, a new popular initiative was launched. So aiming at a national vote to increase the requirements on companies by way of changing the Swiss constitution. And within 2 weeks, 180,000 citizens of Switzerland signed the initiative, which is an absolute record. So in Switzerland, we observe that, let's say, a large part of the politically interested citizens are very, very sensitive to ESG topics.
That's interesting. Bianca, what's your perspective? You're on mute, Bianca.
Really sorry. So thank you for Sue for the invitation, and good afternoon to everyone. In Brazil, we have shifted from government, you probably know, 2 years ago. So we came from a government that was not so focused on environmental issues and returned to a government that is focused on environmental issues. So greenwashing is really an actual risk, more reputational than a legal risk, because here in Brazil, we don't have a specific laws. But companies are dealing with this risk very seriously, because as social media is spread a lot of information and a lot of allegations, accusations, this has been a real challenge to companies in Brazil, especially the multinational ones. And we'll have the opportunity to talk about this over our discussions here, but this is also very important for investment. So Brazil has also developed rules for informations and statements. So here we are aligned with the world, but I think we have a few steps to move forward.
Great, that's a great introduction to the topic. Let's move on. Over the last few years, we've seen many new anti-greenwashing measures come into force across several jurisdictions. Could each of you give us an overview of the regulatory landscape in your jurisdiction? Nate, perhaps we'll start with you this time.
Yeah, happy to. So I think in the US, there are 3 main regulatory regimes that I think companies really need to pay attention to. The first is from the US Federal Trade Commission, the FTC, the second being with the SEC, and the third being with state agencies, such as those in California or New York that enforce local state consumer protection rules and other sustainability-related regulations. And so to take those in turn, the FTC has, this is at the federal level, has authority to bring enforcement actions based on deceptive claims about a product. And that can result in a trial or settlement orders that prohibit misleading marketing and fines. But the FTC itself has brought only a few enforcement actions, and there haven't been any since 2022. So the main significance of the FTC isn't in how it's been enforcing the law itself, but rather the standards that it's generated. It issued what are called the green guides, which have been around since the 1990s, have been updated a couple of times. And these provide specific guidance on various types of environmental claims, and have very specific guidance on what companies can say about topics such as their general environmental benefits, claims that a product is so-called compostable, biodegradable claims, recycled claims. There's like a long list of areas where claims about environmental issues can go wrong. And this guide provides examples of those, like with a great deal of specificity. For example, one of them says that, if a trash bag claims that it's recyclable, but which may be technically true that the material itself can be recycled, but the company knows that no recycler will in practice actually separate out the bags and recycle the product, so that it actually wouldn't be recycled, that would be considered misleading. And so it calls out a bunch of these types of examples. Now, this green guide represents what the FTC, its views on, what the law means, but it's not legally binding at the federal level. Now, this changes when you get to the state level, because state consumer protection laws can be more stringent. In fact, states like California have laws that incorporate and reference the green guides and sort of make those guidance materials hard law at the state level. And so plaintiffs in those cases can, and enforcement agencies can, make claims based on a company acting inconsistent with the green guides. And then lastly, the SEC at the federal level, they have brought some very noteworthy enforcement actions in recent years that focused on false and misleading product or public disclosures in public filings and sustainability reports. And historically, this is consistent with their role as a financial regulator, that they've been focused on actions on the funds industry or targeting advisors or those kind of actors for material misstatements related to ESG funds or failures to have appropriate policies or procedures that have to do with those kind of investments. But in more recent years, they showed an increasing focus on public companies. And they brought high-profile cases involving, say, environmental harm in Brazil that was caused by a mining company, and involving a dam that collapsed that caused extensive environmental harm and loss of life. And this case was focused on the company's prior disclosures regarding dam safety. For example, claims that they made in their sustainability report about safety audits of dams. And that was said to be misleading by the SEC, and a settlement was reached in that case. And then in more recent years, the SEC brought cases based on other sustainability topics, including on social issues, which I thought was a very noteworthy development. There's one case recently about against a video game company called Activision Blizzard, where the company had a scandal, a wake of allegations about harassment and other workplace conduct issues in its international locations. And the SEC alleged that the company had insufficient procedures for analyzing those types of misconduct and didn't have, appropriate governance around it, and that their disclosures didn't include an adequate discussion of those types of circumstances and risks. But in that case, the company settled with the SEC for $1.5 million. But in a related California state case, they settled for $54 million with its civil rights agency. So this, I think, is a great case that shows how you can get tangled up both with federal law and with state law. And sometimes the state law can be even more consequential, far more consequential than the federal law. But so again, those are the three main areas that I would look at, the federal and the state. And with the federal, as I said, we're not really expecting that to be a priority for the next 4 years. But I would say that, it's an open question on certain social issues, right? Like the issues with forced labor and supply chains have been a very bipartisan supported issue in the US. And so I wouldn't rule out scrutiny about public statements on certain social issues over the next 4 years, but certainly on environment, we don't expect that to be a priority at the federal level, but certainly at the state. But I hope that's helpful.
Thanks, Nate. That's very enlightening. It's a little bit depressing. Bianca, What's happening in Brazil?
We have no specific laws related to greenwashing practices. We only have the consumer law that focus mainly on products and services, which are often associated to greenwashing. And this, to me, is a positive thing and not, and on the other hand, not, because greenwashing has been used as a large broad of events. So this allows NGOs and other individuals to claim practices, a lot of practices as greenwashing. And in Brazil, consumers focus on products and services. So from a regulatory perspective, there are these possibilities of sanctions from consumer authorities. We also have a national self-regulation advertisement entity, which is important in Brazil, but also focus on advertisement. And it's interesting that recently in 2022, we internalized a global guide of sustainability and marketing claims that was prepared by the World Federation of Advertisers. And from the investor's perspective, we have our Securities and Exchange Commission in Brazil also enacting resolutions as guidance, like Nathan said about the Green Guide. Nathan, we have a similar rule, especially for disclosure of reports containing sustainability-related information. So the idea is to also create in Brazil this increase of transparency and reliability when we talk about disclosure of sustainability information and policies. So this is the idea of mitigating inaccurate and misleading information in Brazil. And this is interesting because there is a provision that if there is this misleading practices, this causes damages to third parties, they are the duty to repair such damages. So this is how we advance. What is interesting from my perspective is that because of lack of definitions, everyone can claim a greenwashing practice. When this comes to social media, this can increase in Brazil investigations from authorities. So sometimes the claim of greenwashing can be a social claim, a labor violation law, or an environmental violation law. So what we have seen in practice, a lot of investigation proceedings against companies to try to understand if there was violations of the environmental laws or labor laws. So this in practice is occurring instead of the greenwashing itself, but inspecting and investigating the violations of the laws, the specific laws. So this is how is the environment in Brazil. Few lawsuits about products and more this broad sense of discussions against companies in their practices.
Thanks, Bianca. So Daniel, we've heard that the Swiss public are quite greenwashing aware. What are you seeing?
Yes, so in Switzerland, we had until the end of last year no specific legislation on green claims. This has now changed with the beginning of this year. So the Unfair Competition Act was amended by an article which says climate claims must be objective and verifiable and substantiated. So there's a reversal of the burden of proof in case claims are filed under the Unfair Competition Act. And I think what's important to know is that this is, in principle, a very strong legal instrument, because the Unfair Competition Act allows for civil and criminal claims for senior management involved in unfair competition claims, there is a penalty of up to 3 years imprisonment and fines. So and claims can be filed by consumers, but also competitors, also the federal agency. So it's a very strong instrument, but it's rarely used for various reasons. But maybe the stronger instrument, or let's say that the most used instrument, are complaints with the self-regulatory body of the Swiss advertising industry, which is the Fairness Commission. They have 3 chambers which take decisions, and anyone can file easily a complaint through the internet. And these decisions are very professional and sometimes very detailed. So you may recall that there was a decision with regard to claims made regarding a soccer championship and the CO2 neutrality. And this decision is public and can be read by anyone, and it's a very detailed and reasoned decision. Recently, the Swiss television made an article on these decisions by the Fairness Commission and said overall greenwashing is on the decline at the global level, but not in Switzerland. So that we see this as a result of the many decisions of the Swiss unfair or the Swiss Fairness Commission on unfair statements and unfair advertisement. So greenwashing is a topic, and it's still an area where many consumers in particular feel uncomfortable with statements made.
Thank you. Galina, what's happening in the UK?
Yeah, first, just to comment, I'm not sure I agree with the Swiss Commission that the greenwashing is on decline. Certainly that's not the conclusion that you would reach. Just, looking at various advertising day to day, but also judging by the very busy schedule of the UK Advertising Standards Authority that issues its rulings on greenwashing, I'd say almost on a weekly basis. But in terms of the UK regulation, well, unsurprisingly, there's been a flurry of activity, and we've seen new legislation and regulation passed last year. So I'll mention just 3 key pieces in my opinion. And then the first one is the Digital Markets Competition and Consumers Act 2024, which interestingly didn't mention greenwashing specifically, but sort of it comes under broader category of misleading practices, misleading statements. And I think what is particularly significant is that it gives the Competition Markets Authority the power to impose pretty much unprecedented fines of up to 10% of global turnover for making such statements. As I said, it's a very, very new piece of legislation. There hasn't been any enforcement. So I think ultimately it'll all boil down to whether we start seeing such cases or it ends up being sort of a toothless instrument. But certainly it has the potential to really be a game changer. The other really important, again, that's I think echoing what Nate and Bianca were saying, not regulation itself, but guidance, which is really important in this sphere, is the CMA's Green Claims Code. And I would really recommend anybody who wants to sort of sense check any green claim to look at their checklist. It was published about 3.5 years ago. It gets regularly updated, but it's a very good basic sort of narrative which anyone can use to check whether the claims they're making or seeing are genuine, clear, not misleading. And I think what's important to flag is that this applies to all businesses, not only those that are consumer focused. So if it's a business to business company, it's still very much subject to this guidance. Again, we've seen quite a lot of CMA investigations against big corporates, multinationals. We're yet to see a big enforcement action. There is an outstanding investigation against Unilever, so maybe that will give rise to an actual enforcement action, but at the moment remains to be seen. And I think really the approach that CMA have been taking is more sort of taking businesses with it on the green journey and trying to not to sort of apply maybe more of a carrot than stick approach. And the last piece of regulation that I want to mention is the Financial Conduct Authority anti-greenwashing rule. And personally, I think that's, if properly policed, that anti-greenwashing rule, coupled with the sustainability labeling regime that's also been enacted last year, has the capacity to have a really transformational effect on sectors well beyond financial services. And really, I think that's because if you think about it, any business relies on capital to enhance its capacity, its spread. And so if we get to the position where the ability to borrow the funds become conditional on the actual substantiated efforts to become green and sustainable, then it will become the key driver for energy transition. But again, very new, difficult to see exactly how that's going to be policed and applied. But FCA tends to be one of those regulators that actually follows through on its regulation. So I'm sure we'll see something in not too distant future.
Thanks, Galina. We're going to move on to litigation risk. In the UK and in the EU, greenwashing is an increasing litigation risk. What's happening in your jurisdictions? Bianca, shall we start with you this time?
Pleasure. Well, litigation in Brazil, there are a few, and all of them focus on products and advertisement. So this is what we have on a concrete basis. And although there is no litigation in Brazil, I think and we are in an international panel, I think it's also interesting to talk about what is happening with Brazilian companies in US and in Europe, because we have recently seen Brazilian companies being sued in the United States for making unjustified sustainability claims. So I think this is what makes our discussions very interesting. So global businesses and global lawsuits also. So the risks are in Brazil, but I think nowadays the risks are more broadly in this sense. So we also have seen accusations of Brazilian companies related to cotton or supply chains that provide cotton to textile industries that produces clothes for USA and European brands. And also in Brazil, a lot of accusations related to net zero commitments. So like I mentioned, although the expression greenwashing does not exist, and this in a definition is being widely used, and most of the times in Brazil, we see violations of other laws. So I see that there is a trend of litigation, but it's not a reality right now. I think this maybe happen in the near future, but not right now.
Thanks, Bianca. We have in the UK quite a few class actions involving Brazilian companies.
Brazilian companies, exactly.
So Nate, you're next.
Oh, thanks. Well, as I said, with at the state level, we have, I think, a very active, litigation risk of, consumers and other people. From from perspectives, I think of, the investor perspective or from the consumer perspective, and they can bring a wide variety of claims based on these state level laws that I said in some cases tied to these federal standards. And they usually bring in claims of, against state consumer protection laws and other civil claims such as breach of warranty and fraud and with class actions. And so that I think is clearly a trend that will continue. I think one case that I did think it would be probably of interest for everybody, because I think it really shows, at least at like the federal enforcement level, how things are likely to change, was this recent case against a company named Keurig, who you may know produces those individual coffee pods that are. This was a case that was brought by the SEC just last year, like late last year, and it involved the SEC saying that the company's, public statements were, false and misleading, because they made a claim that the pods that they used were, quote, effectively recyclable. But they, in fact, the allegations in the SEC order were that the company knew that two of the country's biggest recyclers would not, in fact, separate out the pods and actually recycle them. And they reached a settlement with the SEC for $1.5 million. And this was considered to be somewhat of an aggressive case by the SEC, because they're really supposed to be focusing on material issues to investors. And this was viewed as perhaps arguably more of a consumer issue. But I think what really is most noteworthy about this is that this came right, near the end of 2024, right? So this is, I think, shows that kind of momentum we were talking about before, and it also signals, say, where the SEC is going in terms of its approach to these kinds of cases going forward, because there was a dissent that was issued by one of the SEC commissioners in that case publicly, where they were saying that this case, was incorrectly, resolved, because the commissioner said, and this is the quote, it would expose companies to endless second guessing by the commission unless they pad any statements with a mountain of caveats, right? So this is a clear indication that this SEC commissioner, and this commissioner was appointed by the Trump administration before, viewed this as an overly aggressive case, one that imposes too much burdens on the business, and therefore was incorrect. And as the saying goes, today's dissent becomes tomorrow's majority, right? And so, with this week, we're essentially in this Tomorrowland here. This is the new reality where I think these kind of views, I think, give us insight into at the federal level, the approach that will be taken by enforcement agencies. But as we emphasized before, the federal part, is often the more insignificant part of these enforcement actions, and a lot of the exposure comes from these state actions and private litigation by and civil lawsuits by plaintiffs. So that's just to illustrate the context I think we're moving into here.
Thanks, Nate. What's the litigation landscape in Switzerland, Daniel?
So there is some litigation currently going on with regard to climate claims against Swiss companies in local courts. There are on a regular basis cases brought at the OECD national contact points, which is a sort of a special procedure established under the OECD guidelines for multinationals, So these cases are public, and some cases are dealt with in these contact points. And then, of course, there are the state courts with regard to unfair competition claims. This is a new topic. We'll see what happens in this area, and we will continue to see cases dealt with the Fairness Commission of the Swiss advertising sector. So some action, however, more to come most likely. Just to give you an idea now with regard to the responsible business initiative, that the second one that has been launched now at the beginning of this year. On the website, there are more than 20 cases of alleged severe infringements on environmental laws, on human rights, all with names of big multinationals, stock exchange listed and not listed private companies. But if you look at this, the real court in Switzerland is the court of the public opinion and the opinion of the stakeholders. And this court is a very tough one. And looking just at the cases on the website of the initiative shows you in a very good manner how burning this topic is, and multinationals are extremely under pressure and well advised to take this very serious with regard to their sustainability footprint, to climate footprint, but also then with their green claims.
Thanks, Daniel. Galina?
Yes, so I think I'd agree with Daniel's point that I think we are at this interesting moment where there is real public scrutiny, pressure, and a lot of momentum behind these claims, which I think hasn't yet translated in a lot of privately pursued litigation, but it seems like it's likely to in the near future. But the three cases that I wanted to mention that are important in this arena that have been litigated or are litigated before the English courts are the Client Earth against Shell, McGuffey and Davis, and the ongoing Drax litigation. The first two are interesting because they were brought as derivative claims against the company's directors or the trustees of a pension fund in the second example. And really, they boil down to the allegations of the alleged failure to take meaningful steps towards achieving the objectives that those companies or funds set out towards energy transition or divestment from investment in fossil fuels, etc. Ultimately, both claims failed for a number of procedural but also substantive reasons that would be very important to look into if anyone's thinking of bringing a greenwashing claim. They range from sort of court saying that they shouldn't have really been brought as a derivative action to saying that whilst the court might have some sympathy with what the claimants were saying, the actions taken by the trustees or directors didn't cause any actual or actionable loss. And that really is, I think, at the moment, the sticking point for these types of claims, because it's one thing to be able to say that certain practices potentially are misleading, but proving that those practices actually caused loss, that is really difficult, together with some points on reliance. That's why I think what is potentially promising and the litigation that is worth looking into is the ongoing Drax claim, because that's an action that is brought by private shareholders of Drax, which is an energy company, off the back of a regulatory action, which essentially is saying that the claims that the company was making about the effects of its business practice on environment were significantly underplaying the negative effects of those practices. And that regulatory action led to a quite substantial dip in the share value of the company. So that ability to link the action with the laws is what's so far been missing, obviously, in many actions that's been brought by NGOs or sort of activists. Remains to be seen what the case is at quite early stages, so remains to be seen how the courts deal with it, but possibly could pave the way for many more claims of this nature in the future.
Thanks, Galina. So I knew we would. We're running out of time. We've talked a lot about problems. Let's spend a few minutes looking at the potential solutions. What are your thoughts on best practices? Let's start with you, Daniel.
Yes, so I'll maybe make a very general remark because there's a lot to be said about this. So the easiest way of dealing with the many challenges of sustainability in a large sense, including avoiding false or unsubstantiated green claims, is to be a purpose-driven organization, which means an organization which has, of course, its commercial purpose, but also cares about the long-term well-being of all people and planet, as it has been defined in a recent UK standard. And once companies are purpose-driven and care about the long-term well-being of us humans and our natural bases, ultimately the existence of the consumers, I think then it's an easy way forward to integrate this into strategies and then make it actionable. So I think every company should, in its DNA, care about these considerations, and then it comes easily to deal with all these different challenges. So that's maybe something I would recommend, to think about it starting from a governance perspective. And the other topic, I think, which is important, and you mentioned it before, Sue, it's so important to make green claims. Green claims are testimony of companies being purpose-driven and having the long-term perspective on their mind. So it's very important. But of course, it must be substantiated. They must be true. But it's very important. I love companies that make green claims.
Great.
As
Me
a
too.
consumer.
Nate, what do you think?
Well, I think Daniel made some excellent points. So especially like the importance of really just ingraining this kind of thinking into the culture of companies, and that just being so important. I think most people are very familiar with like well-established common practices to mitigate these kind of risks that are emphasized in all of the official guidance that I think we've all been talking about, such as avoiding vague claims, making sure that the claims that are being made are reviewed and vetted by like a range of stakeholders who can kind of look at it from different perspectives and sort of anticipate where something could be viewed as potentially misleading, or where it may require a very clear explanation of what the company means, to avoid being accused of greenwashing. And then of course across all of this, making sure that any claims can be substantiated by clear documentary evidence. I mean, I think those are very well established practices that flow through all this official guidance. I think the only thing that I would add to that is companies should really be keeping an eye out for issues that are emerging as new environmental issues that are really important to people that you may not have been thinking about at the time when you made certain claims or had certain marketing kind of campaigns. I think a great case that I think could be illustrative of this is one in the past couple of years against REI, which is an American outdoor apparel and equipment company, and it was the focus of a class action by plaintiffs who claimed that their advertising and marketing was misleading because the company used what are called PFAS, these forever chemicals in its waterproof gear, that interact with people's skin, and that the arguments by the plaintiffs were that they wouldn't have bought this had they known, and it is very inconsistent with the company's entire marketing strategy and communications that really try to target people who are environmentally conscious, care about the social issues, care about safety, care about the environment, and they didn't ultimately succeed in their claim. It was eventually dismissed because of issues about how the plaintiffs had tested the particular jackets they bought and whatnot. But it was very, these kind of litigation, they take a lot of resources, attention, management attention to resolve, and I think it does really illustrate the risks of, say, these new waves of things that they get a lot of attention, that people really care about, to really, as they come up, sort of look back at what you're saying about those topics and related topics and sort of think through how do claims that, say, looked very well, very well explained, very well supported at one point in time, how might that have evolved over time? And do we need to add and say anything additional about these things to head off different ways that people could look at our public statements going forward? So I think that's the only thing I would add to what Daniel said.
Thanks. Bianca.
I think I would make mine all the inputs that my colleagues made. And as an environmental lawyer, I think we need to continue to value genuine sustainability efforts, the voluntary commitments, and the companies that do this. So I would add that, at least in Brazil, the obvious sometimes is not obvious, because these general statements are sometimes done, and I think a revision of the marketing statements, of the publicity campaigns, even by legal, internal or not, are extremely advisable. There's invisible work that prevents all this discussion, because the concrete cases in Brazil were exactly about this, advertisements of super green tires, as 100% green, or 100% recycle, all eco-friendly, friends of nature, and things like this, coming from Amazon, and friends of indigenous peoples, and things like this. I would add that we always advise companies, to try to conduct regular audits and assessments internally, and look carefully about certifications, because there are a lot of discussions about relying on a certification that sometimes has a specific scope and the stand does not cover everything, or sometimes certifications that are not fully reliable. I think this is also something important. What we are doing today, I think, is extremely important, because these issues are alive issues. So greenwashing is changing every day, new laws, new rules. So every company that operates in this international landscape must follow these applicable rules on a frequent basis. I think this is why lawyers are important here. And I think Sue made a spoiler, but I think supply chains are the real challenge for greenwashing, and I think we're going to need to have one single event for this, but I think this is what companies will have to dealing with. So to me is what I would add. So help multinational companies to audit its supply chains. In Brazil, there is not a legal duty to do this, but this is the reality of the world.
Thanks, Bianca. So Galina, you've got a minute.
Yes, I think we'll follow up with our joint checklist. So expect this from us in writing. But very quickly, my top 5 suggestions, and I hope we don't have any or many people from marketing team, or at least if they're there, they'll understand. But I think my advice would be, don't simply rely on what your marketing team is saying. Do check. They might just not have the kind of the whole picture and understand the potential risks. Question the data, ask to see the underlying source of data. Ensure that your marketing statements are scrutinized as closely as your corporate reporting. Be consistent across all your corporate communications. Make sure that the statements you make on your website, social media, and annual reporting are all internally checked out. And finally, I think to echo what Nick was saying, review your communications and sustainability strategy regularly.
Great. Thank you very much. We have time for one question, and it's directed to Nate.
Thank
Miranda
you.
Ching from Cobra and Kim is interested in your views on forced labor, and in particular the US FLPA, which we don't have an equivalent of in the UK. Can you talk about some of the challenges you've faced in advising clients?
Absolutely, and I love this question, and it's obviously for me and most, I think, lawyers in the U.S. who specialize in business and human rights. This is a very, very hot topic that has generated a lot of attention and enforcement, and is a big concern for clients across a number of industries. And I hope that I get a kind invitation back from you, Sue, and Galina, to speak on your forced labor focused one, because I think this deserves a lot of. There's a lot of interesting discussion, a lot of interesting recent cases and developments and things on the horizon about this. I think Miranda, just to your specific questions. The challenges in advising clients and how to rebut the presumption that this is the real issue. If goods are coming from the Xinjiang region, they're subject to this rebuttable presumption that they're made with forced labor and they will be denied entry and potentially detained at import to the U.S. Now, we have not seen companies succeed in rebutting that presumption. If the goods are found to be coming from that region, it's very difficult, if not impossible, to convince the U.S. government that they were not made with forced labor if there's evidence that it's coming from that region. And the simple fact is, the government will need substantial evidence to back off of that position, that suspicion. And their view is that reliable information cannot be obtained through audits currently in that region. So it's a very uphill, difficult battle to convince them of that. On the other hand, we have had a lot of success with the government in showing them, proving through documentation that the goods in fact did not come from Xinjiang. And there's a lot of guidance out there from the regulators about the types of documentation they expect and that can be persuasive, and they've issued guidance on that we leverage in our advice. And then I think the last part of your question is, have we seen companies successfully get off of the list, this entity list where they're listed as prohibited from importing? And we have not seen companies succeed. There are a couple that are bringing claims in the Court of International Trade, and we're watching those with a lot of interest. But we have not seen success in getting companies removed from that list. But I hope that covers your questions, and I'm of course happy to talk on that issue more.
Thanks. All that remains is for me to thank all of the panelists for their insightful answers. And we will be running a supply chain due diligence specific webinar shortly. So please watch out for that. Thank you also for everyone who's attended. Thank you.
Thank you very much.
Thank you.
Thank you.